going to take multiple sessions, and that is constitutional law. I'm sure you're all experts on it already from the reading that we emailed to you a couple weeks ago. Hopefully, most of you have read a good part of it anyway. And we're really happy to have with us today Professor Josh Blackman, who flew up here from Texas just to be with us for a couple of days. Really appreciate that, and give you a really good overview today and get into really deep tomorrow. With that, actually, I'll get out of the way and give it to you, Josh.
Thank you so much. It is one of my favorite things in the world to teach people about the U.S. Constitution. I absolutely love it. You're in for a treat. So I have a treat for you. I have all pocket constitutions for you. So please just pass these around. Yeah, I always keep one in my suit jacket close to my heart, so it's always right over here. No. Much sweeter. My goal today is ambitious. In 2 hours, and I will keep on time, I want to walk you through the three major founding documents of the United States of America. The Declaration of Independence, the Articles of Confederation, and the U.S. Constitution. Now, I presume that you know nothing about constitutional law. I presume you know nothing about American history. Are there any Brits here? You're from the UK? Okay, good. It's going to be ugly for a few minutes at the beginning. But I presume you know nothing about the little war between the United States and Great Britain. I will start you from the very beginning and lay the foundation of how our Constitution has endured for over 200 years. It's the longest serving Constitution in the world by many, many years. You ready? Okay. I'm going to lecture. If you have a question, you can put your hand up. I'm not going to call anyone today. I'll probably call people tomorrow. But this requires me to be very precise as I go through things. Our story begins on July 4th, 1776, which most Americans know is the day where you shoot fireworks and you have popcorn and barbecues, maybe you watch a baseball game. But the significance of this day is that this was when our independence was declared. And the phrase Declaration of Independence, it was a declaration. It was a statement to the world. And when you think about the Declaration, I want you to think of it as a legal document, right? Think of it like a divorce, right? Where you had two people who were in a relationship, and one of them says, this is not working out, let's break it, let's dissolve it. But instead of just ghosting the person, right, here they actually put a list, reasons why separation became essential. And this was the Declaration, see, does this thing work? Oh, yes. Oh, it's very hard to see. Of the 13 United States of America. Now let me read the first two paragraphs. These are the most famous that people usually read. It begins, when in the course of human events, it becomes necessary for one people to dissolve, to break apart, the political bands which have connected them with one another. That is the band between Great Britain and the 13 colonies. And to assume among the powers of the earth the separate, right? It's like Brexit, right? Separate and equal station to which the laws of nature and of nature's God entitle them. Now, why are they appealing to this law of nature and God? What is this stuff? There is no code for how to break up, right? There's no written document that explains how you separate from one country to another. This was appealing to a higher power, and they channeled the power of the Almighty. A decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. Now here comes probably the most famous line in the entire document you've probably heard before. We hold these truths to be self-evident, right? This is so obvious, it doesn't even need to be said. That all men are created equal. Now the dilemma, right? At the time this document was being drafted, all men were not equal. There was slavery in our country. Women did not have the same equality that men had. So from the very beginning, there was a contradiction, a tension in our founding charter. that they are endowed by the Creator with certain unalienable rights, that is, rights that cannot be taken away by government. And what are these rights? Among them are life, liberty, and the pursuit of happiness. This is a John Lockean concept. We've said Locke before. All right? The rest of the document is a list of grievances, right? Complaints. The same way if your landlord, didn't fix your heat, right? You put together a list of complaints. The document functions in a very similar fashion. Some of these will be familiar, some that might sound a little bit bizarre, but I walk you through the history. Jefferson writes, by the way, Thomas Jefferson was one of our first presidents, was the lead author, along with John Adams and Benjamin Franklin, very prominent statesmen in American history. Jefferson writes, to secure these rights, government are instituted among men, right? Why do we have government, right? Why do we come out of the state of nature, so to speak, and create government? It's to secure these rights. That's why we have government. And where does government get the power? From the consent of those who are governed, right? People don't have a divine right, a monarchy, if you will, right? The right to govern comes from the consent, the vote, if you will, of those who are governed. But that consent can be withdrawn whenever any form of government becomes destructive of these rights. The people have the right to abolish it and create a new government that's more likely to secure their happiness. The idea is government exists to protect rights, and when they fail to protect those rights, that government has to be abolished, and a new one instituted in its place to secure these rights. Now, Jefferson explains, you don't have a civil war, right? You don't have a revolution for light and transient causes, right? You need something really big. For example, a long train of abuses, absolute despotism. When you have an absolute despot, it is the people's right to throw them off. Now think about this for a minute. Who are the colonists talking about here? The despot. It was the king. Exactly, the monarch, the King of England, King George III. Now, today you can call the queen a despot and nothing happens to you. But back in the 1700s, if you call the head of state, your queen, your king, a tyrant, what happened to you? Executed. These people were signing their death warrants. They recognized that by publicly calling their monarch, their king, a tyrant, they were offering themselves to be executed for treason. If they lost this battle, which was no guarantee, if they lost this battle, they would all be hanging. But they had an expression, they'd rather hang together than hang apart. And they're willing to join together and put their names on this document to declare their independence from the tyrant that was King George III. That's why I asked, are there any Brits here? So this is a very, the first part of the class is a little bit anti-British, but we'll move on.
So it was signed before the war?
Yes, this is what triggered the war, right?
I was thinking it was at the end.
No, exactly. This was signed actually in the middle of the war. Battles had already begun. And this was basically signed and was sent across the sea to England. And the king was like, what the heck is this, right? What's going on with these? And he thought these colonies were just being silly. And he would just smack them back, and he did not win. So he writes, the King of Great Britain, right there, they name him, has created injuries and absolute tyranny. This was very brave to say this, right? It's not like when you go tweet against the president. Like, that's not a big deal. This actually counted. This was an act of heroism. People say, oh my God, Trump. This is real, right? This actually has significance. Okay. So again, think of this as like a divorce document, right? If you file a brief for divorce, you have to give reasons why you're separating. Maybe there's abuse, maybe there's neglect, there are different reasons. So Jefferson lists paragraph after paragraph of why the colonies, the 13 colonies in the United States, were separating. Let me read through some of them for you. I won't read all of them. He has refused his assent to laws. What the heck does that mean? In order to enact a law, the colonies needed the permission of the king. Why is that a big deal? They could not govern themselves. And the first freedom is the right to govern yourself. You don't think of this as a freedom like speech and religion. No. The most basic freedom we have is the right to govern ourselves, because that's what allows us to create a government to secure the other rights. That's our most basic freedom that we have within this civil society, right? He has dissolved houses of representatives, right? He has prevented people from being elected. He has blocked the population, that is the immigration of these new colonies. He's made judges dependent upon his will. What does that mean? Well, generally, judges have some sort of independence, right? Not so in England. A judge drew his salary from the king. And if the judge made a ruling that the king didn't like, guess what happens? You're fired. So the judges were dependent upon the monarch for their office. And independence is an essential attribute. That's why our judges in the United States serve for life. Federal judges have life tenure. You get appointed to a judgeship when you're 45, sit until you're 90. They can't get rid of you. And it's directly because of that fear of the king's abuse of the judiciary. He has kept standing armies. Okay, what does this mean? Well, today, I think almost every country in the world has a full-time military. Put your hand up.
No.
Okay. Today, almost every country in the world has a full-time military, right? Professional soldiers. Not back then. At the time, people would join what was called a militia, which is like a temporary military. That in times of war, you'd go fight, and after the war was over, you go back home. But the king was keeping permanent soldiers, standing armies in the colonies. And this was to abuse the colonists. The king would keep soldiers quartered in people's homes, as people would have to keep soldiers in their houses. He cut off their trade. He imposed taxes without our consent. You may have heard the expression taxation without representation. Every license plate in the city has it on it, right? The king would impose taxes, but they wouldn't get any representation for those taxes. He's deprived us of the trial by jury. Now, in the United States, juries are very important. I think most European countries, they don't exist anymore, or they're mostly dissolved. Juries were very significant to the founders. He suspended our legislatures, he's plundered our seas, and he's taken captive people on the high seas. Okay, now we get to the meat, right? We just listed all the grievances of what we're not happy about. Now we get to the point of what are we going to do about it? And he writes, in every stage of oppression, we have petitioned for redress in the most humble terms. Right? We've asked for help. What was the response? Nothing. More injuries. And he writes, a prince whose character is thus marked by every act which may define a tyrant is unfit to be the ruler of a free people. Again, they are calling their own king a tyrant. This was a very significant statement to make. The next paragraph is fascinating. Jefferson explains, look, we are not at war with the British people, right? Our grievance is with the king, right? Our British brethren, our British brothers and sisters, right? We have a common kindred, a common bond with you. But we're going in a bad direction. And we might be friends in peace, but in war, we are enemies. And we get to the conclusion. We, therefore, the representatives of the United States of America, appealing to the supreme judge of the world, God, declare that these united colonies are and of right ought to be states, not just any states, free and independent states. Just look at this sentence for a minute. I love this sentence. I always pause here, right? They start off as colonies, right? There are 13 colonies. And by the end of the sentence, there are 13 free and independent states. It's remarkable, right? How much time does it take us to write something? In just one sentence, you go from a colony to a state. I love that sentence, my favorite in the document. and they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved. And now, as free and independent states, what can they do? Conduct war, conclude peace. They need to fight a war, don't they? Make alliances. During the American Revolution, the Americans took a treaty with France because the French hated the British. What else is new, right? Basically, during the war, the French helped Americans to hurt the Brits. It's all just, nothing ever changes. Are there any French people here? No? Okay, fine. Well, good. I got other countries. Establish commerce and do all the other things states ought to do. At the very end, they says, and for the support of this declaration, with a firm reliance on the protection of divine providence, that's God, we mutually pledge to each other our lives, our fortunes, and our sacred honor. And 56 people then signed the document. And I just, again, every one of these people, had the war gone the other way, would have been executed. It's like you're publicly stating, here are the treasons, right? Here are the traitors. Put them on a list, name them. And here's where I live too. This is a state where I live, so you can find me more easily, right? So there's no doubt. It was a very bold act. Have you been to the National Archives, any of you yet? If you go to the National Archives, they have a great exhibit where you actually see the Declaration of Independence. It's a huge document. It's very faint. The ink is almost completely faded. It's hard to even see it. But I encourage you to go while it's still visible, because maybe in a generation or two we can't even see it. But it's so faint, it's hard to read. But you'll see these signatures in big, big print. Okay, so they all sign it. That's 1776, and the Declaration is signed. Over the next 6 or 7 years, depending on how you count, a war was fought between America and the British. And against all odds, these pathetic colonies defeated the greatest empire the world had ever seen, who had a navy that spanned the entire globe. Right? The sun never set in the British Empire, as they said. And eventually, peace arrived, and a treaty of peace was reached. But the treaty of peace only governed the relationship between the United States and Great Britain. But it didn't govern the relationship between the United States, right? How would this new government exist, right? What would be the system of laws for this new republic? The very first document that was developed was called the Articles of Confederation. Now, when you hear Confederation, you might think, oh, the Confederacy, like the American South in the Civil War. But a confederation is just a league of countries, right? There was Greek confederations, there were Italian confederations, lots of different, I think there were German confederations, right? There are lots of different countries around the world that had these sort of confederacies. And the Articles of Confederation was the first attempt by the Americans to create a system of government. Now, I'll cut to the chase, it didn't work, right? It barely lasted 5 or 6 years until we got our Constitution. But you need to understand the Articles of Confederation in order to understand our Constitution. Our Constitution came from the failures of the Articles of Confederation. In other words, the things that didn't work so well in the Articles of Confederation gave rise to how we have things in our Constitution. So you need to know both documents. And the second thing you need to know is this document was not viewed as unifying, right? This wasn't a country with 13 states. These were 13 states that were confederated, that were aligned. Even, today we say United States of America is, right? It is a country, singular, one. But back then you'd say something different. I'll just wait for the pass. Thank you. It's an emergency. Okay. Today we say something like the United States of America is one country. But back then we'd say it differently. We would say the United States of America are, right? It's not one country, it's multiple states. And just look at the very first paragraph, right? It says, this is an Article of Confederation and a Perpetual Union between the states of New Hampshire and Massachusetts and Rhode Island and Pennsylvania, etc. Right? These were independent states that came together for purposes of creating this union, this confederacy. And look what word they use, this perpetual union. What does that mean? It will be around forever, right? Perpetual. Was it perpetual? Nope. Didn't make it 5 or 6 years. Right, so this was wishful thinking, right? It's like, okay, let's hope this lasts forever. It didn't. Narrator, it didn't last, right?
It's like a divorce.
Exactly, yeah. We've had 2 big divorces, right? Sensing a pattern, right?
It's like a marriage. Yeah.
Yeah, very good. And it begins, the style or the name of this confederacy is the United States of America. And it explains that each state, right, each of the separate nations basically, retains its own freedom and independence. And the powers. Okay? So what happens? Yes, please.
The 13 colonies, there were all the colonies in the states, or there were other colonies that never binded to the independence?
It's a good question. So if you couldn't hear the question, the 13 colonies were the ones who declared independence, but there were colonies in Canada. There were colonies further west in the United States. There were colonies in Latin America and South America. The only colonies that declared independence were the 13, basically the eastern part of the United States. The other ones did not declare independence. Although the American independence actually caused a movement worldwide with Simon Bolivar and other people in Latin America who sort of became their own independence and revolutionary from Spain and Portugal and other nations. Does that help your question? Thank you. So let's explain how this works, right? On July 4th, 1776, who had all the power? The king, right? Then the Americans declared independence. All the power that the king had was transferred from the crown to each state, right? The states absorbed whatever powers the king had. Now what happens is they ratify this document, this Articles of Confederation. And the states say, okay, you know what? We like having all this power. We want to make a union, right? A nation. So we're going to give up some of our power to this central government, right? We're going to delegate. That's the word. You guys know the word delegate, right? We're going to delegate some of our power. See, it says expressly delegated right there in the first part. And I'm going to take my jacket off. It's a little bit hot here. Hope you don't mind. It's very stuffy in here. We're going to expressly delegate some of our powers to the central government. We keep everything else, but we delegate certain powers to the central government. Okay? All we're doing is making a firm league of friendship. Like the Avengers or something, right? This is a league of friendship, which we're together. And why are we doing this? Oh God, here it comes. It's a block away. For our common defense, security of liberties, and general welfare. Okay? They are making the basic steps of forming a government. And they have certain expectations, right? And this becomes very important. How do you deal with certain issues that might spill over from one state to another? For example, trade and commerce, right? Can New York erect a tariff on all goods from New Jersey, right? Can New York block all agriculture, all produce from Pennsylvania, right? One of the early ideas is that states would not erect trade barriers to other states. That it would basically be, think of like a trade zone, right? Where each state can freely trade with the other state. And what about people, right? Would you need permission to travel from New York to New Jersey? Basically a passport, right? They said no, right? That you have free ingress, free entry and regress, free exit to go from state to state. And then we have this paragraph, right? What about criminals, right? What happens if a criminal in one state flees to another state? They'll be extradited, right? We have extradition treaties that exist. So it's basically creating the same, almost like a European Union in a somewhat similar fashion. If a person, criminal in country A, flees to a country B, you extradite them, you return them to their home. Okay? But there's something else going on here. They weren't just talking about people committing crimes. They were also talking about slavery. There were some states that had slavery, and there were some states in which slavery was illegal. And one of the most divisive issues was, how do you craft a country in which slavery is allowed in some places but not in others? And this was one of the provisions they came across, that if a slave runs away from one state to another, they'll return the slave back to their home state. And this was one of the compromises that the framers reached. They don't use the word slavery, right? They were very afraid of using that word, because they didn't want to put it in writing, but that's exactly what they were talking about. Okay? Section 5 describes the form of the government. Now, have you been to the Capitol yet? Have you visited there yet? Okay, you'll go there next week. So you'll see it's this huge building, right? With a dome in the middle, and there's a part on the left and there's a part on the right. We have two branches of our legislature. We have a House of Representatives, which is based on population, right? Where every state has at least one representative, but some have maybe 30 or 40. The other part of the building is the Senate, right? The Senate is based on fixed terms. Each state has 2 senators. We have 50 states, 100 senators, right? We have this balance where bigger states get more representation and smaller states get less. Makes sense, I think. Not so in the Articles. Instead of having 2 houses of government, they had only one, right? They had one house of government. And each state had how many votes? 1 vote. So a big state like Virginia had 1 vote, and a little state like Delaware had 1 vote. You can imagine they create a lot of, jealousy and anger, right? Why should all of our people have less representation in this little stupid state? I'm sorry, Delaware is a very small state. This little state like Delaware, it's very small. You can drive across in about 2 hours. Okay? Part 6 explains what states can't do. Effectively, states cannot engage in foreign policy. They cannot have ambassadors. They cannot enter into treaties and alliances. They cannot grant titles of nobility. They cannot impose duties and tariffs. That's for the central government. They can't keep vessels of war, basically a navy. They can't engage in war without consent of Congress. Okay? All charges of war, all declarations of war had to be done by the central government, the Confederacy. Now, where was the Confederacy to get money from? Could the Confederacy tax people? No. The Confederacy had to ask the states for money. They would make what were called requests or requisitions of the legislatures of the states. Do you think the states actually paid up? Nope. One of the huge problems you had with the Articles of Confederation is they had no money. They were broke. George Washington, right after whom this city is named, was our general, the commander-in-chief. He was always begging, please, we need money for weapons, we need money for clothes, we need money for food. And they're like, we have no money, right? The big failure was this government lacked the power to tax. They can only make requests for money. And I'm sure you know, if you make a request, people say no, what are you going to do? You can't make it work. Okay? All right, so go down a little bit. We're going to go, okay. So you asked about Canada, other countries. There's actually a provision that says other colonies might be able to join, right? It says Canada can join automatically, but no other colony shall be admitted unless the 9 states agree. In other words, they anticipated that maybe Canada would join. They didn't. They're still their own country, right? But they were allowed to perhaps join. Okay. All right. Here we go. This is part I want to read. Article 13 is the basically end of the document. And what it says is that every state is bound by the determinations of this Congress. And the Union shall be perpetual. There's that word again, perpetual. It wasn't. And any alteration, any change to this document must be confirmed by the legislatures of all the states. In other words, if you want to change this document, all the states have to agree. I'll give you a preview. Our Constitution was confirmed without all the states agreeing. So the very act of putting this document saying that all states have to agree, our Constitution disregarded that and said, no, 3/4 is enough. Okay. That's it for the Articles of Confederation. Any questions on the Articles? No?
Yes.
Yes, ma'am. And well, if you say your names, I'll try to learn your names. It's a quick class, but I'll try. What's your name?
Monica.
Monica, thank you.
Thank you. So, there's one of the articles expressly implied that the colonies were the 13, well, the 9 states, but also Canada, but excluded the Indian tribes.
Yes.
So, how is that today? So the Indian tribes are still separate?
Yes.
Separate?
Yeah, so,
That remain?
yeah, exactly right. Under American law, the Indian tribes are sovereign nations. They have their own laws, their own governments, they have their own constitutions, they run their own government. There's a lot of interaction between the federal government and the Indian tribes, but they are not part of the Union.
Okay.
The fact that they're U.S. citizens is because Congress gives them citizenship. They're not what's called birthright citizens. They're basically separate nations. If you ever go in the United States, they have like casinos and like gambling, which are not permissible outside, but they're allowed to their own governments. Okay. Any other questions? Okay. Let's go on to the Constitution, which you came here to learn. So again, some backstory. The Articles of Confederation were drafted and approved by 1781. For about 5 or 6 years, we were living under this government, but it wasn't effective. The Articles Congress couldn't raise money. They couldn't tell the states, give me money, right? The states just didn't pay money. States began to erect trade barriers, right? So if you wanted to ship goods from one state to another, there were tariffs and other trade barriers. And by 1787, a movement emerged to propose amendments to the Articles of Confederation, changes. And a group was organized to meet in the summer of 1787 to provide amendments to the Constitution. They did more than provide amendments. They wrote an entire new document from scratch, which became the Constitution of the United States of America, which I gave all of you to carry around and keep close to your hearts. This document was drafted in the span of about 4 months. And it was remarkable how much they approved and how much they developed in such a short time. My goal for the next hour or so is to walk you through the entirety of this document. I teach a class in constitutional law that maybe meets for 56 hours. All right? I only cover a small fraction of the Constitution. But this is your crash course. Well, I will go through every provision, every clause, every amendment, which you will never see again, but you will see it here. And tomorrow, what we'll do is talk about the cases of the Supreme Court. My plan for tomorrow, if you saw my reading, which I hope you guys did, is to go over the top 100 cases decided by the U.S. Supreme Court. 100, it's a lot of them, right? We have 6 hours, maybe 15 cases per hour, 100 cases, right? But that's what we call constitutional law. That is a law that's been interpreted by the courts. That's tomorrow. Today is not constitutional law. You get the real thing, right? The Constitution itself. And I'm going to do something that might be surprising. I don't think I'm going to mention the Supreme Court once, not a single case. I want you to learn the Constitution as it was written, not as the court has interpreted. Because in many regards, the document that exists, under glass in the National Archives, is not the document the Supreme Court interprets. In fact, much of our American constitutional law has very little to do with the actual Constitution. It's sort of just common law, made up. Use whatever word you want to see. But my goal today is to stick to the actual text. Okay? And it begins with three majestic words. We the people of the United States. We the people. And again, you have this tension, right? Who are the people? Men, women, white, black, slave, free, right? But by starting with this lead, this we the people, it creates what we call a big promise, which I think can be lived up to in due time. We the people of the United States. Not the people of New Jersey and New York and Pennsylvania. No, this is a country, one country. In order to perform a more perfect union, not perfect yet, we're getting there, we establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, our children, right? This is the mission. This is why they're doing this document. We ordain and establish this Constitution for the United States of America. This first paragraph is known as the Preamble, right? It sets a very broad purpose behind the document. It doesn't actually tell you what's going on, but it's sort of a general guidance of how to read the document. Now the Constitution is divided into several articles, right? There are seven articles in the Constitution. I'll give you a preview. Article 1 concerns the legislative powers, the powers of Congress. You can follow along in your own books, exactly. Article 2 concerns the power of the executive branch, the presidency. And Article 3 concerns the power of the courts, the judiciary. So if I just say Article 1, I'm talking about Congress. If I talk about Article 2, I'm talking about the president. And if I say Article 3, I'm talking about the courts. And it's actually very useful. They're arranged in sequential order. It makes actually a lot of sense. The Articles of Confederation are nonsense. It's just sort of just jumbled together. This actually has a logic and flow to it that makes it very easy to study. Okay. It begins, Article 1, Section 1. All legislative powers herein granted are vested. Vested means like given, right? Are vested in a Congress of the United States. What is a Congress? It's a Senate and a House, two bodies. Now I want to start from a general premise. We said on July 4th, 1776, all the power belonged to the king. The next day, the power belonged to the states. But when the states approved this Constitution, they gave up some of their authority. They delegated some of their authority. They kept most of it, right? The states still kept most of their power, but they gave certain authorities to Congress. What did they give up? The legislative powers granted. In other words, the powers given to Congress were given up by the states. The states gave up this power and they delegated it to the central government. What does that mean? If a power was not delegated, who has that power? The states. Bingo. Now I'll just jump ahead and give you a preview. That is what is the 10th Amendment of our Constitution, right? Ratified in 1791. It says, the powers not delegated to the United States by the Constitution, right? Powers not given up. Who have them? Reserved to the states or to the people. This is the concept, is who has this power? Do the states have it or does Congress have it? If the states have it, then Congress doesn't have it. If Congress has it, then the states don't. There's some overlapping powers, but generally either one or the other has it. So most big Supreme Court cases are asking, who has the power to do this? The states or Congress? The answer is usually not both. Okay? So we begin. All powers granted in the Congress. Article 1, Section 2 describes the House of Representatives. Members serve a term of 2 years. If you want to be elected to the House, you have to be a citizen for 7 years and at least 25 years of age. And you have to serve 2-year terms. The idea was fresh blood, right? Anyone up for election every couple of years, very high turnover. The next paragraph is one of the most infamous in the Constitution, but I want to explain how it works. We described that in the Articles of Confederation, there was a weird setup. Each state had only one vote. The big states had one vote, and the little states had one vote. That wasn't very fair. In the House of Representatives, the votes were decided based on population. Bigger states had more votes in Congress. Smaller states had less votes in Congress. I think it makes sense. But what about taxes? Now Congress could directly tax people. They could, that's the phrase, direct tax, right? They could directly tax the people. And they would set the taxes based on population. Bigger states would have to pay a bigger share of taxes, and smaller states have to pay a smaller share of taxes. Again, I think it makes sense, sounds fair. But what happens to slavery, right? This was a dilemma. Southern states had high population of slaves. What do you do with the slaves? Well, the southern states said, aha, I want you to count all of our slaves for purposes of representation. 100% of them. If you count 100% of the slaves, the map looks different, right? The South has more votes in Congress. And guess what? More Southern representatives provide more pro-slavery legislation. And the northern states, who didn't have slaves, would have a smaller share in Congress. So the North said, aha, we have an idea. Instead of giving you full 100% representation, we count 60% of your slaves. That's not what you were taught, was it? This is what's called the 3/5 clause. 3/5 is 60%, right? The Northerners said, listen, we will give you 3/5 of your slaves. We'll count 60% of representation, and to make up for it, we'll only count 6% for taxes, so your taxes are lower. So in other words, you get lower taxes and lower representation, not 50%, a little bit better, so you get 60%. This was one of the first compromises in the Constitution. It was to ensure that the southern states didn't have an overwhelming monopoly in the Congress. Oh, and by the way, how are presidents elected? Based on the number of members of Congress you have. So the more congressmen you have, the bigger share of what's called the electoral college you have. There's a reason why almost every president in the early era was a Southerner, with the exception of John Adams. Because the Southerners' favorite Southern presidents would back slavery. Right? To understand this document, you need to understand the backdrop of slavery and how they made compromises, hoping that this problem would dissolve later. It didn't. Right? You had a bloody civil war over this question. But they don't use the word slave. It's very careful. They're afraid of using that word slave. Look what it says. The whole number of free persons, excluding Indians who are not taxed, that was your question a few minutes ago, right? 3/5 of all other persons. They don't say 3/5 of slaves. They say other persons. Now, we all know what that's referring to. Now, why didn't they use the word slaves? They were embarrassed. They were ashamed. They knew they were doing something bad. And they were simply hoping that at some point in the future, the situation would be improved. But at the present moment, they would not have been able to actually create a country had they not made these sorts of compromises. So this was like a you know the expression kicking the can down the road? Right, just deal with it later. They're hoping to deal with it later. Ma'am, is your hand up?
Yeah, so they count the slaves as persons, not as property?
Yes. In fact, they were counted as 3/5 of a person with respect to representation and taxation.
Okay.
Yeah.
So for some issues there were property, and for other
Yeah.
were people.
But we'll get to that point in actually a few minutes. They were not citizens. In fact, the Constitution drew a distinction between persons and citizens. Citizens were afforded certain rights that persons were not. So that's another way. We'll get there in a couple minutes, I promise. Yeah, a huge chunk of my constitutional law class is about slavery. It's a significant portion of early American law that we have to go through. Okay. The next paragraph counts how many members of Congress each state had. Okay. Then we go to Article 1, Section 3, which describes the Senate. Right. We have what's called a bicameral legislature. Bi means two, cam means house, bicameral legislature. The House was backed on size. Bigger states had more representatives. The Senate's different. Each state has 2 senators. It was fixed. This was a compromise, right? That both the big states and little states would be happy. So even today, a huge state like California has 2 senators. I live in Texas, right? Huge state, 2 senators. Delaware, also 2 senators, right? So a lot of people think the Senate's unfair. I'll leave that debate for another day. But you have the states drawn up in this fashion. Now, people voted for members of the House. How were senators chosen? Not by election of the people, but by the state legislatures. That the states would pick their senators. And the idea was the senators should be responsive to the states. This was later removed by constitutional amendment. Today we vote for our senators. We do not have the states picking them anymore. What are the qualifications for a senator? You have to be 30 years old, a little bit older than 25, and 9 years a citizen. Also, what happens if the Senate ties, because there's an even number of members? If the Senate ties, the vice president casts the tie-breaking vote. Okay? The Senate also conducts impeachment trials, right? Impeachment's a 2-step process. People don't always appreciate this. Step number 1 is the House of Representatives impeaches someone. That's basically like an indictment, right? We're saying we allege you committed a crime. Then a trial is actually held in the Senate. And in the case that the president is the one being impeached, then the Chief Justice presides. We've had 2 presidential impeachment trials for Andrew Johnson and President Clinton. We'll see. So far we've had 2. Okay. Let's move on. I can skip a few of these things. Okay. Article 1, Section 7. Remedies a huge problem with the Articles of Confederation. The House can raise revenue, right? The House can pass bills to collect taxes. And how are bills formed? Right? How is a law made in the United States? First, the House of Representatives approves it. Second, the Senate approves it. And then the president signs it. You can do the other way, Senate first, House second, doesn't really matter. But one house, the second house, and the president signs it. The president can veto the bill. That is, say, no, I don't want to sign this. What happens if the president vetoes a bill? The Congress can override the veto. You need a 50% vote to approve a bill, but a 2/3 majority to override a veto. And it happens all the time. 2/3 of both houses of Congress say to the president, you are wrong. That's how a bill becomes law. Okay, any questions so far? Yes, in the back. What's your name?
Maria.
Maria, thank you.
It doesn't matter, I mean, you can choose where you enter a bill?
Yes. With the exception of bills to raise revenue. Bills to raise revenue must begin in the House, but otherwise all other bills can start in either house. Right.
Can do anyone, I mean, aren't there some issues that are just exclusively given to government, for example, for the representatives?
Oh, no, private citizens can introduce
No,
bills.
no, no.
Only elected members.
Yes, but, for example, in Chile, I think there are some issues that just the executive branch can send it to as a bill.
Well, the president can make a recommendation.
Okay.
Right, the president can recommend, here's the bill you should back. But then a member of Congress has to introduce that bill into the chamber.
Okay.
Right, the president can't directly introduce a bill to the chamber. That makes sense?
Yeah.
Is that clear? Okay, other questions? If you have any questions, please just raise your hands. I don't always remember to ask. But I love questions. Makes a chance to drink some water. Okay. All right, let's move on. Article 1, Section 8 is probably one of the most important sections of the Constitution. This provision lists all of the legislative powers that Congress has. Remember I said, the states have this huge body of power, what's known as the police power. But the states give up some of that power to the central government. Article 1, Section 8 lists each of those powers. And there are, I always forget the number, 17. There are 17 separate clauses. Anything Congress does needs to be based on a power in this article. If the power is not listed here, and maybe a couple other places, Congress doesn't have that power. So always we ask a question when Congress passes a bill, where do you get the power to do this from? What authority are you relying on? Congress can't just say, I want to pass this bill because it's a good idea. That's not enough. I want to pass this bill because it's a serious problem. That's not enough. They have to have the enumerated power. What does enumerated mean? It's written down. Congress lacks a general power to enact legislation to make people happy. The states have that power. The states can enact just about any law they want because they have the general police power, plenary power. But the central government lacks that power. They can only enact which is enumerated in Article 1, Section 8. Make sense? All right, let's walk through them one at a time. The first one is, again, significant. They can collect taxes. They can spend money. Right? This was critical. So now the government would not be bankrupt anymore. They would actually be able to collect revenue from people. Not only can they collect revenue, they can borrow money. Right? International banking got an early start here. Congress has the power to regulate commerce with foreign nations. Not the states, Congress. Right? States can't erect treaty barriers or trade barriers. States can't enact tariffs. That's for Congress to do. Congress can regulate commerce among the several states. That is, if I want to ship a good from New York to New Jersey, states can't block that. Congress is responsible for regulating interstate commerce. As well, to your question before, Indian tribes, right? It'd be the central government that regulates the relations between Indian tribes and the United States, not the states. The states cannot mess with the tribes. That was for government of the central government to do. Section 4, to establish rule of naturalization, that's immigration, right? It'd be the Congress, not the states, deciding who becomes a citizen of the United States. Bankruptcy law, right? A lot of states pass very friendly laws to debtors, right, where they would just forgive all debt. No more. Now Congress will be responsible for saying bankruptcy laws for debtors. Yes?
Why bankruptcy is here? Why
Yeah.
why is not property? Is bankruptcy?
What do you mean?
I think in the Constitution section.
Yeah.
Is for example copyright. For
Yeah.
example war. For example tax is very important.
Yeah.
This country. But bankruptcy is a common.
Bankruptcy, okay, so the question is here, why is bankruptcy in the Constitution, right? Is it important? Yes. So what a lot of states would do is it would pass laws that would extinguish debt. And banks hated that. Debt.
Because they were broke.
Loans, yes. So if a lot of the people had a lot of loans, had a lot of debt, the states would just wipe out all the debt. And the banks hated that. Right? So this was designed to prevent states from eliminating debt. And only the central government would enact a uniform rule of bankruptcy that would be the same in all 13 states. That way that Virginia couldn't say, okay, well, just forgive all debts. People love that, but the creditors, the bankers hate that. Make sense? A good question. Yes, and what's your name? Ursula, thank you. I'm sorry, what was your name again?
Danda.
Was that?
Danda.
Danda, thank you. Yeah.
I have a question about the Trump wall. So,
Oh, that's a good hour.
So in Mexico, so how is it the Congress that should pass the law?
Okay, let me answer your question. Yes.
Yeah.
Thank you, Ursula. Yeah, thank you for the question, Ursula. Okay, so the question was about the wall. That took all of like 45 minutes. So I get paid the small bucks. Okay. Okay, so the short answer is, where is it? No, there's actually a provision. Where is it? Okay. We're only a little bit further down, but I'll jump here, right? So Article 1, Section 12 says that Congress has the power to raise and support armies, but no appropriation of money shall be used for longer than 2 years. Okay, what's an appropriation? An appropriation is when Congress authorizes money to be spent, right? Congress says, executive branch, please spend $1 million to buy a tank, right? Spend $2 million to buy an airplane, right? So Congress gives the executive branch authority to spend money. The question in the wall litigation is, has Congress already given the president money to spend on certain construction projects? And the answer is far more complicated than I can do in an hour. But the answer is maybe. There's some pots of money which actually authorize construction projects. And the question is, does the wall fit within the parameters of that delegation? And that's something that courts are fighting over now. Right, but the president can't just say, you know what, I want to spend $1 billion on the wall because it's a good idea. He has to cite an appropriation from Congress. And now the courts are fighting over whether the appropriation actually covers that. Just 4 days ago, the Supreme Court ruled that the construction can go forward. So these are live issues, and I can't go too far into it. But Rosa, does that answer your question a little bit?
Yes.
Okay, thank you.
But there it says, like, no longer term than 2 years.
Yes.
So how fast you can build a wall?
2 years. The one he's going on expires in a few months. In fact, the reason why the president took the case to the Supreme Court is that the appropriation expires in September. And they said, if we don't spend the money now, we'll never be able to spend it. That was the reasons why he went to the Supreme Court now. Yes, what's your name?
Sashi.
Sashi, thank you.
Yes, but which is the role of the Congress as regards foreign policy? Because, it's in connection with what Ursula asked before. At the end of the day, the interaction with Mexico and the borders of the United States,
Good.
and how the president decides to allow.
Yeah. So we'll get to the president in a minute, but generally the president does foreign policy, but the wall is on U.S. soil, right? It's on our side, right? I love Texas, right? So it's on our side, right? The president can't build something without the permission of Congress, not the authorization. Now, if the president wants to send, for example, an ambassador overseas, the Senate has to approve that ambassador, right? There's what's called checks and balances, right? Where even the president has power over foreign policy, he needs the Congress's permission to do certain things.
But do you have any specific provision on the Constitution itself as regards foreign policy or not?
We'll get there in a few minutes.
Okay.
I promise. We'll get there. Now we're getting warmed up. Okay, any questions? All right, let's go back up. Bankruptcy, I think we were at last, right? What else can the federal government do? Article 1, Section 5, coin money. Lots of states were printing paper money. Paper money was worthless. Like in many countries around the world today, paper money is worthless. So that the United States would coin actual money with a uniform sense of measurements. They would punish counterfeiting money so that the states couldn't make fake money, like monopoly. This one people always chuckle at, to establish post offices. Why is this important, right? This was a way to unify the country. Yeah, if you have a document in Maine and you want to read it in South Carolina, you need to have a way to transport the documents across the country. It's very significant, the Postal Service. Today it's like whatever, email. But this is a very big deal back then. This is actually what's called the Intellectual Property Clause, right? That they can give authors and inventors the rights to their discoveries, which is what we might call a patent, right? Might call a copyright, might call a trademark. This was basically establishing what we now think of as IP, a very forward-looking provision. Number 9 is important. To create courts below the Supreme Court, we have 3 levels of courts, of federal courts in this country, right? We have the Supreme Court at the top, about maybe 3 miles that way. Below that, we have the Courts of Appeals, and below that, we have what are called the district courts, or the trial courts, right? Those are the federal courts. We also have state courts. Every state has their own judicial system. But Congress can create the lower courts, the inferior courts. Congress can create laws to punish piracies and felonies in the high seas. Right? The pirates were actually a big problem back then. Not so much today, but it was a huge deal about piracy. Congress has the power to declare war, not the executive. Right? The president is the commander-in-chief, but Congress gets to declare the war. Congress can raise and support the armies and give money for the military. So the president can fight all he wants as long as Congress gives him the money to do so. Congress provides for the Navy. Congress calls forth the militia. This is a good one. Congress exercises jurisdiction or control over the federal capital. Here, us, right? This right here. What the hell is Washington, D.C.? Wait, where are you, right? It's not a state. You are not in a state. The purpose of Washington, D.C. is to be a federal district, the District of Columbia, for the central government, for the capital. The thinking was like this: why would we put our capital inside another state where that state can take it over? Right? It was meant to be an independent, neutral place that was not an actual state. And Congress has control over this place. Have with me, Silver. Yes, what's your name?
For example, you were
What's your name?
Oh, Andrea?
Andrea, thank you.
Yeah, you were explaining before about the meaning of the concept militia in
Yeah.
previous documents, but in this one it's already a constituted army. Is that correct, or does it still
No,
have the same
there was still a
connotation?
militia. Yeah, the standing army, we didn't have a standing army. What would happen is if Congress declared war, Congress would approve money to hire soldiers. Yeah, so the militia is only called forward when there's an actual need, an actual crisis. Number 17 is probably the most important clause in the Constitution. It's what's called a necessary and proper clause, the elastic clause. Let me give you an example. We know Congress has the power to create postal roads, right? And make a post office. Does Congress have the power to buy horses and wagons? Well, the Constitution says you can build roads, right? And you have a postal system. Is there anything in the Constitution about buying horses and wagons? No. In order to have a postal service, do you need horses and wagons back then?
Yes.
I think we do, yeah. You don't know, traveling by foot the entire country is not possible. What the necessary and proper clause does is it gives Congress additional authority to execute its other powers, right? Look what it says. Congress shall make laws which shall be necessary and proper for carrying to execution the foregoing powers. In other words, in order to actually make a functional post office, they can do stuff that's necessary and proper. Is it necessary to have horses? I think so. Is it proper to have wagons? I think so. Is it proper to hire a letter carrier to actually bring the mail nationwide? I think so. This provision gives Congress extra power. We'll study a case tomorrow called McCulloch v. Maryland about the Bank of the United States, right? Did Congress have the power to create a bank, a national bank? Except for tomorrow. But this provision is so significant because Congress is not confined to the 16 clauses that came before it, right? You have 1 through 16, that's nice, but also 17 asks, what else can you do? Can you do something to implement those other powers? And almost every Supreme Court case you'll read is premised in the necessary and proper clause. Yes, what's your name? Jonna.
In this version that you have given us, and also in my version, there are like 18.
Yeah, you can count them differently. Don't worry about it.
How did you count it?
I merged two of them.
Okay.
I know the counting differently. Don't worry about it. It's the last one.
Okay.
Thank you. Yes.
Maybe Maria was related to foreign affairs and treaties,
Yeah.
treaties like the Appropriation of Human Rights and that. Does the president?
We will do treaties in the next section, next article, in 10 minutes, I promise. And so I hand over here for is there a hand somewhere? Okay. All right, so that's Article 1, Section 8. All right. Article 1, Section 8 lists the powers of Congress. Article 1, Section 9 puts some limitations on Congress's power. And we start again with a discussion of slavery. The very first clause concerns what's called concerns the slave trade. We know what this is, right? Where slaves were brought across the ocean to the states. It says the migration or importation of such persons. Again, they don't use the word slave, they say such persons. This slave trade will not be prohibited until 1808. This was kicking the can down the road. We're saying, we're going to keep the slave trade in existence for 20 years, and we'll deal with it later. The hope was, maybe we won't need it in 20 years. Indeed, it was abolished in 1808, but the Constitution says you cannot get rid of this for 20 years. The next clause, the privilege of the writ of habeas corpus shall not be suspended. Habeas corpus is a procedure by which a person who's arrested can challenge his arrest, can go to a judge and say, why am I being held? Only Congress can suspend the writ of habeas corpus. Okay? This is also about the wall. No money shall be drawn from the Treasury unless you have an appropriation by law. Right? In other words, unless Congress appropriates a spending, the executive can't take the money from the Treasury Department. Okay? Everyone with any questions so far?
So you can actually suspend the habeas corpus?
Congress can. Here. Congress can in case of rebellion.
And has that happened?
Yeah. There have been some insurrections and mutinies in various states where Congress has, things are pretty bad. President Lincoln, during the Civil War, suspended the writ of habeas corpus. And you have a case tomorrow called ex parte merriment, which asks whether the president can suspend the habeas corpus writ if Congress wants to do it. During the Civil War, Congress also suspended the writ of habeas corpus. People were arrested and held without any judicial process.
But not in more recent times, right?
What's that?
Not in more recent times. I mean, we're referring to Lincoln now.
There was a question during the. You're familiar with Guantanamo Bay, which is a military installation in Cuba, which is run by the Americans. And there was a question whether the writ of habeas corpus runs to Guantanamo Bay, and there's complicated cases on that. But generally, Congress does not suspend the writ. Okay. Good. Thank you. All right. Let's go down to the next section. Okay. Article 1, Section 10. Article 1's the longest, so after this we're actually going downhill. It's easier. This puts limits on the states. The states cannot enter treaties and alliances. Right? States cannot engage in foreign policy. That's not for states to do. Okay? Okay, we're done with Article 1. Okay, that's everything from Congress. Any questions on Article 1? Okay, we're right on schedule. And I'll get you out of here on time, don't worry, I promise. Article 2. Article 2 governs the executive, the president. And it begins, the executive power shall be vested in a president of the United States. Not 3 presidents, not 5 presidents, 1 president. And all the power, all the executive power is vested in that one office. This is often a concept called the unitary executive theory. Unitary executive, the idea that there's some power that's not written down. We don't know what it is. It's the executive power. And the president then can list that power and use it. And various presidents have relied on unenumerated powers which are not written down as part of their wartime authority. How are presidents elected? It's a little complicated. It's based on something called the Electoral College. Every state has certain votes in the Electoral College. We do not elect the president based on the popular vote. As you know, the presidents can win 51% of the vote and still lose the presidency. How? The Electoral College. How do you work it? You count the number of representatives and senators each state has. So let's say a state has let's say a state has 1 member of Congress and 2 senators. Right? 1 member of Congress, 2 senators, 3 electoral votes. Let's say a state has 30 representatives and 2 senators, they have 32 electoral votes. So there's actually a bias for the states with less population that have more control. You add together how many electoral votes they have, and the president's selected. And today we have a vice president who runs with the president. Originally, it worked differently. Whoever got the most votes was president, and the runner-up in second place was vice president. It was a disaster. It was a disaster. Imagine Hillary Clinton being Donald Trump's vice president. Just think about it for like 5 seconds. Actually, that'd be hilarious. Right? Trump better get someone to taste his food for him. Yeah. Oh, just one at a time. I'm sorry, what's your name again?
Lynn Marie.
Lynn, thank you.
I have a question
Yeah.
regarding the parties. Where in the Constitution it is established that only you have conservative and Democrat?
It's not. The parties, the political parties, Republican and Democrat, only emerged after the Constitution was drafted. That didn't exist at the time of the framing. That came around much later.
So there is a possibility that representative is not part of either of.
Absolutely, yes. Yes. Yeah, I mean, the political parties today are pretty strong. There are third-party candidates. They sometimes win. But it's not like in European countries we have, 40 different parties. We don't have the coalition building, right? The sort of, we don't have that. It's pretty, you're one or the other. But thank you for the question. The president has some qualifications. He must be a natural-born citizen.
I'm sorry, I have.
Sorry, yeah.
Joanna again, regarding this choice, the electors, are they bound somehow?
No, well, they're not. It's actually a very important question that came up in the last election. I go to the polls, I vote, and let's say that Trump wins majority of the votes in Texas.
Mm-hmm.
President Trump picks the electors who then vote in the Electoral College. It's an open question whether they're required to vote for Trump. In the last election, there were some electors who did not vote for Trump. They voted for Hillary. And it's an open question in the courts of whether a person would be forced to vote in the Electoral College a certain way. I don't have an opinion on it one or the other, but the Constitution doesn't say how they have to vote. It's not clear. That's a very good question.
Okay, so the electors are actually kind of
People.
chosen by the...
Yes, the candidate chooses the electors, but it's not clear they can make them vote a certain way.
So the electors could choose whatever they want personally. Okay.
The idea originally was that these were going to be wise people who will not elect a bad person, and they would choose wisely. But today it's basically 100% whoever their guy wins and they vote for their candidate of choice. But in the last election, a couple electors voted against President Trump. We lost a few votes here and there. It happens.
Excuse me,
Yes,
these
what's your name?
Victoria. But these electors are appointed just to appoint the president, and
That's
after
it. They're done. They have one
That's it.
job.
That's one job. After that, they won't be a congressman or
Nope.
a speaker of the Senate.
Nope. That's their only job. It's not a, it's an important job, but it's over in, basically a couple of days.
And do they do a long campaign to be appointed as?
Usually they're people who are friends of political parties, someone they trust. But, it varies by state. It's not a very important position, but it can be significant in a close election. And we have a presidential election coming up in about 18 months. We're almost there. Yeah, go ahead. Oh, okay. Any other questions? Yeah, so what's your name?
Carlos.
Carlos, thank you.
Yeah, you talked earlier about executive powers of the president. Are those two powers the ones that permitted President Trump to declare national emergency?
No. So the question, you couldn't hear it, was the President's declaration of an emergency based on executive powers? The answer is not. Congress enacted a statute that says the President can declare an emergency whenever he wants. And when the President declares an emergency, certain pots of money become available to spend. So the entire emergency thing wasn't actually like Schmidt, right? It's not like Third Reich. This is basically using laws that Congress enacted in the 1970s to spend money. That's what it was. Good question. Other questions? Okay, let's move on. Okay, so if you're a natural-born citizen, which I think excludes, probably most of you, sorry, but it's part of the Constitution. Okay. If the president becomes ill or can't discharge his duties, the vice president becomes the commander-in-chief. The president's salary is fixed. That way Congress can't reduce his salary if he misbehaves. Makes sense. The president takes the oath of office. I will faithfully execute the office of the President of the United States and will do to the best of my ability, preserve, protect, and defend the Constitution of the United States. Okay. That's the oath the president takes when he has his inauguration every 4 Januaries. Okay, questions so far? All right, let's keep going. Article 2, Section 2 lists some of the president's powers. Not all of them, but some of them. Why only some of them? Because a lot of the president's powers are not written down anywhere. They're in the ether. Begins, the president is the commander-in-chief of the army. He controls the military. A civilian in control of the military, which is actually a very important innovation. It was not a military figure, it was a civilian who was controlling the military. But keep in mind, the president needs Congress to appropriate money for the military. The president needs Congress to declare war. The president can't go into war by himself unless Congress approves. Now, there's other things that happen, we'll talk about maybe tomorrow, but under the original design, the president was limited what he could do by himself. You asked about treaties a few minutes ago. The president can make treaties. He can negotiate treaties. But the Senate, by 2/3 vote, has to concur. So the president cannot enter into a treaty by himself. Now, he ignores that, all presidents do. They create called executive agreements, right? Executive agreements like a treaty, but no one votes on it. Whatever. I'm telling you, the stuff I'm teaching here is not what actually exists. I want you to start with the real stuff, we'll do the garbage tomorrow, okay? But treaty is 2/3 vote, okay? What about ambassadors? I think you asked that. The president can appoint ambassadors and other ministers for foreign countries, but again, you need a majority vote in the Senate. So the president can't send a diplomat overseas unless the Senate approves, which, again, it's a check. The president's in charge of foreign policy, but you need a vote of the Congress. Yes, what's your name again?
Andrea?
Andrea, thank you.
Yeah, so is this rule also applicable for the president to be able to withdraw from treaties?
No, what a good question. The Constitution is silent on withdrawing from a treaty. It's silent. And the courts have never really answered this question. Most presidents say they can withdraw from a treaty by themselves without having congressional consent. The Senate has actually tried to sue the president when he withdrew from a treaty, but under general norms, the president can withdraw a treaty. For example, the Iran deal wasn't a treaty, it was an executive agreement, so there's nothing to withdraw from. Paris Accords. Did Congress vote on the Paris Accords? I don't think they did. Most treaties in the United States are not actually treaties, they're called executive agreements, which means the president didn't get Congress going in, and the president can exit without going through Congress. But in any event, even if it's a treaty, the president can exit by himself unilaterally. Yeah, what's your name?
My name is Hamilton.
What's that?
Hamilton.
Thank you.
Just one question. The Congress nowadays is formed more for Democratic representatives?
So currently, we have two houses. The House is controlled by the Democratic Party, and the Senate is controlled by the Republican Party.
Okay.
It changes every 2 to 4 years. It always flips around.
Okay.
Okay. Same judges, both the Supreme Court and the lower court. The president nominates them, and then the Senate confirms them by majority vote. So again, treaties, the 2/3 vote, but for other appointments, majority vote by the Senate. The House has no role here, it's only the Senate. Only the Senate.
So the president could get into a treaty negotiation and over there say yes, but when he becomes to the Senate,
They say no. It happens.
it's over.
Yeah, the Senate can vote down a treaty, and that's it. The president can only negotiate the treaty. And if the Senate says no, it doesn't have any effect.
It's applies to Paris Agreement,
I'm sorry?
to the Paris Agreement.
I don't know that the Paris Agreement was ever submitted to the Senate. I think it was an executive agreement.
Okay.
Because the Senate would have voted it down. They didn't have 2/3 vote for the Paris Agreement.
And just one question. And does it happen usually like the president like making treaties abroad?
Well, the reason why the president doesn't go to the Senate anymore is because it's hard to get 2/3 vote on anything, right? It's much easier for the president to call an executive agreement and just not worry about the Senate. That's generally what happens.
But it's strange because your bypass constitution.
Of course it is. Of course it is.
Normally, I mean, the other rules of,
Yes.
just denominated.
Yeah, and I mean, here's what happens, right? President Obama negotiates all these wonderful executive agreements. The president goes, nah, never mind. There's no legal binding effect.
It's the same thing with Cuba then.
Exactly, yeah. President Trump rolled back some of the Cuba sort of arrangements. They weren't treaties. Now, what often happens is Congress will enact a treaty and then enact legislation to implement the treaty. The president can withdraw from the treaty, but the legislation is still binding. He can't withdraw from legislation. So let's say, we enter into a convention on refugee rights, right, or a convention on torture, and then Congress enacts legislation to implement that refugee convention. The president can say, okay, here, ignore the treaty, but you gotta still follow the statute. So when you merely have an executive agreement for Paris or Iran or whatever else, and there's no legislation, you can just throw it in the garbage. It's not worth it. Yes?
So if Trump withdraws from NAFTA today,
Well,
What
NAFTA's
would happen?
tricky. NAFTA's, we're getting off field, but
Yeah.
NAFTA's tricky because there's a lot of legislation that implements it. So even if you withdraw from the NAFTA treaty, they still bound by legislation to implement it. So it's not so simple. Which is why the Paris, if you're talking about Paris, there's no legislation, it's only executive agreement.
So that is why maybe he hasn't done so?
I think withdrawing from NAFTA is almost impossible. I mean, to actually effectively withdraw, it would just not be feasible. Given all, you have, 50 years, 60 years of legislation? Good.
Thank you.
Okay, other questions? Yeah. All right, let's move on. The president can also fill certain vacancies when the Senate is in recess. The president gives what's called the State of the Union. It's an address to the country. The president can be removed, right? He can be impeached. How? If a majority of the House says he committed a high crime or misdemeanor, the Senate holds a trial, he can be removed from office. Any questions? Yeah, please, go ahead. And what's your name again? I'm sorry. Vetoes, thank you.
So the reason for impeachment is conviction, treason, bribery.
High crimes and misdemeanors.
High crimes and misdemeanors.
Yeah,
So
yeah. Treason,
anything
bribery,
that
and
would
high.
get into high crimes.
Yeah. The Constitution doesn't define what a high crime is.
So I am guessing that Clinton was impeached by that one.
Clinton
Because
was
it
charged for
treason.
perjury and obstruction of justice. Those are the things he was
So it's a
impeached for.
high crime. It's not in the bribery or treason.
It was not bribery. Treason and bribery are very specific acts.
Yeah.
Everything else is basically high crime misdemeanor.
Crimes and misdemeanors.
Yeah. And it's high crime and misdemeanors. It's not high crime misdemeanor. Yeah. Yeah. What's a high crime? What's a misdemeanor?
Mueller report, sir.
What?
Mueller report right now. So they're investigating.
Yeah. Well, thankfully that's over. But yeah. Yeah. Thank God. Yeah. Go ahead.
No, but I was about to talk about it. So the Russian issue.
Oh man, it took 1 hour for Russia. Okay, we're.
No, was considered as.
Is there any Russian collusion in this room? I don't know.
But it was considered as perjury as well, or not? Or treason?
Well, no one's charged the president with any of these items. The allegations in the Mueller report was what's called obstruction of justice, or perversion of justice, I think it's also called. Obstruction would be an impeachable offense in general. Unclear if in this case it was, but President Clinton was charged with obstruction of justice because he lied to the grand jury.
But, I mean, how can you convict the president if he's in position?
That's exactly the point. He's removed from office. If the Senate convicts him, he's no longer the president.
Okay, so the Senate actually does the.
It's a trial. Yeah, and the Chief Justice of the Supreme Court, John Roberts, would actually preside at the impeachment trial. We've had 2 impeachments of presidents. No one's been removed from office. President Andrew Johnson was a president after Lincoln, 1870, give or take, him off by the year. He was almost removed by 1 vote. If there was 1 more vote, he would be removed from office. You need 2/3 to remove. He had 2/3 minus 1. So 1 vote short of removal. Really close. Really close. What else?
It's
Yes.
exactly clear the role of the president in the bill approval. He just sign it. I mean,
He can veto it or sign it, yes.
but he has a discretion in it. Or
Yes, yeah, if he doesn't like it, he can veto it, otherwise he can approve it or not. But the lawmaking is almost exclusively by Congress. Congress is the lawmaking. Makes sense? Yeah.
Is it limited in time when he has to make this decision?
Yeah, he has got 10 days to make a decision. Yeah, the president has 10 days to decide whether to veto or approve it. Okay, other questions? All right, let's keep going. We got a lot more Constitution. Article 3. Article 3 concerns the judiciary, the courts. And it begins, Article 3, Section 1, by creating the Supreme Court of the United States. Congress can establish other courts, but the Supreme Court itself is created by the Constitution. And the judges of the Supreme Court hold their office in good behavior. And their salary, their compensation cannot be reduced. What does that mean, good behavior? They can't screw up. So long as judges don't screw up, they keep their office. And if they screw up, they can be impeached and removed from office, the same way the president can be removed from office. And we have had judges who are impeached and removed. That happens every now and then. Not often, but judges who engage in bribery, right? Judges who engage in other crimes, they can be thrown out of office. Okay. Article 3, Section 2 defines what's called the jurisdiction of the courts, right? Federal courts have what's called limited jurisdiction. They can only hear certain kinds of cases. For example, if I live in Texas and I sue someone in Virginia, we have what's called diversity of citizenship. We can go to federal court. If there's some case involving the Constitution or the laws of the United States, you go to federal court. I can also go to state court. There's always an overlap between the two. But in some cases, the Supreme Court has what's called original jurisdiction, meaning you go straight to the Supreme Court. If a case involves an ambassador or other public ministers, you go right to the Supreme Court. If you have a conflict between two states, you go right to the Supreme Court. Okay, that's it. Doesn't say much about the courts, right? The courts are viewed as the least dangerous branch, or the most dangerous branch. But there's not much about what the courts do at all. It's pretty brief. Any questions about the courts? What's up here? Okay, let's move on.
What's corruption of law?
Oh, that's a good one. Hold on one second. So let's say I commit a crime, right? And the government punishes me. And they punish my son. And they punish my grandson. And they punish my great-grandson, right? You would actually have certain punishments where the entire bloodline would be punished. Yeah, so the Brits did that. It was pretty serious. So we don't have that. In other words, you are only responsible for your own misdeeds. Your own children and your family will not be punished for your own misdeeds. Yeah?
How the judges, the members of the Supreme Court are appointed, all by the president?
The same way as ambassadors, right? The president nominates them and the Senate approves. Yeah, by 50% majority vote. So the president nominates a judge and the Senate has to approve them. It's not unilateral. Now lots of judges are voted down. It happens quite a bit. All right. Any other questions on the judges? All right, let's go on. Article 4. Full faith and credit, right? Let's say that I have a contract in one state and I move to another state. Will that contract be honored? Yes. All records, public acts are given full faith and credit between the states. Very important provision. The next one goes to your question about citizens, right? Citizens have certain rights, what are called privileges and immunities. This is a funny word, but it refers to certain natural rights, if you want to use that phrase. Right to own property, right to pursue a trade, things of that nature. Privileges and immunities. Here we have,
Sorry, who entitled the privilege or immunities to be declared a citizen? God.
Yes. Yeah, these were rights that were considered natural, that were innate, that no government could deprive you of, fundamental rights.
But then, who decides who the persons are?
Oh boy. The Constitution does not say who a citizen is. It's silent on that question.
That's because then women will not be citizens at that moment.
Well, it doesn't use the word man, it uses the word citizen, doesn't it?
Citizens and persons, but it doesn't say who declares citizens or who declares persons.
We'll do a case tomorrow.
Okay.
Have you read? Called Dred Scott versus Sanford from 1857. That will discuss the exact proportion of who is a citizen of the United States.
Okay.
I'll get back to your question. I'll call on you for that one, okay? Make sure you read it. Yeah, it's 12 hours. Here we have a provision about extradition, right? That if you flee from justice, you're extradited back to your state. But again, we have slavery. A person held to service or labor, which is a slave. They don't use the word, but we all know it means slave. That if she escapes from one state, to return back where they came from. Article 4, Section 3 discusses how new states can be admitted. By the way, Canada, your limited time offer has gone. You have to go through the normal process, right? You don't get easy admission like you had before. But there was a provision for easy admission to the country. All right. Article 5 is how to change the Constitution. Recall that the Articles of Confederation required unanimous consent to make a change. No more. Now you can change the Constitution through a two-step process. Step number one, 2/3 of both houses of Congress propose an amendment. So 2/3 of the House and 2/3 of the Senate. Then 3/4 of the states ratify. So you basically 75% of the states, 3/4, to approve a change to the Constitution. It is very, very hard to amend the Constitution. That's why we only have 27. In 200 years, we have 27 amendments. How big are your constitutions? Right, thousands of amendments? I don't even know. Long? What?
No, in my case, they're not that many, but it's a very recent constitution, it's from '85.
Oh my God, it's like 20, 30 years old. Okay. We have 27 amendments. It's very short. Some people argue that it's too difficult to amend the Constitution, right? That should be easier. But we have a very hard Constitution to amend. But the upshot is only really important stuff makes it into the Constitution. Everything else just goes to statute, which is not the end of the world. Here's an important provision. This provision is called the Supremacy Clause. It explains that the Constitution and laws of the United States are the supreme law of the land. What does that mean, supreme law of the land? There's nothing higher. And what happens if there's a state law in conflict with federal law? Controls. Yes. Anything in the Constitution of any state notwithstanding. So if there's a state law that conflicts with a federal law, the state law is void. It's a nullity. The U.S. Constitution controls and the federal law controls. And treaties, true. You love talking about treaties, right? Treaties are above state law. So if a state law conflicts with a duly enacted treaty, the state law is a nullity. This provision is so important because it prevents the states from being nations unto themselves. Right? The states cannot go against federal law. They cannot go against international treaties, etc. Right? They're bound by this entire construct. Questions on Article 6? Okay. We're actually done with the Constitution. We do the amendments yet, but we're done with the Constitution. Article 7 is the end. How do you make this Constitution ratified? 9 states out of 13. But wait a minute, Josh. Didn't we say that you need all 13 colonies or all 13 states to approve the change? No. Only 9 are needed. Let me get this straight. The Constitution went into effect without the consent of all the states. For about 2 years, there were a couple states that were, they were strapping it along. So you actually had some states that were still saying, we're not part of your country, and they were sort of dragged in. Eventually they agreed. They had no choice. But the very nature of our Constitution disregarded the terms of the Articles of Confederation. You could say our own Constitution is unconstitutional in some regards. But here we are.
So the Constitution overruled the previous, the Confederation?
There's not a good answer for that question.
Okay.
The previous Confederation said unanimous consent, all 13 states, right?
Mm-hmm.
This says 9.
Mm-hmm.
Now, eventually, all 13 states went along, but for a couple of years, we only had 9. So, effectively, our Constitution ignores the document that came before it. Kind of weird, right?
Yeah. But both are valid.
I don't think the Articles of Confederation have much validity anymore. It doesn't really have any. It has no. There's some miscellaneous things, perhaps, but it's pretty much gone.
So no one ever actually refers to Articles of Confederation?
Generally not. I do, as a professor, but in most legal practice, you're not going to cite it. Probably should. Maybe you do. There are some old treaties and land grants to the Indians that do implicate the Articles of Confederation, so it actually has some rare, like, a treaty negotiated under the Articles might refer to it, so there's some really old stuff, but it doesn't happen very often. That's important to know. Questions about this part? All right, we are done with the Constitution, but now we get to the amendments, right? There are 27 amendments. When the Constitution was signed on September 17th, September 17th, 1787. It's a holiday, it's called Constitution Day, one of my favorite days of the year, right? September 17th, 1787 was signed. But at that point, they needed 9 states to ratify. And then conventions, meetings started in all the 13 states to decide, should we adopt this Constitution or not? Some states were very excited, yes, let's adopt it. Other states were not so excited, no, we don't want it. And other states were a little bit in the middle. They said, well, we like it, we want some changes, right? It's good for a start, let's make some amendments. And a number of the states actually proposed changes. And they said, we will ratify this on the condition that you make some changes down the road later. And that's what gave rise to the first 10 amendments of the Constitution, right? 10 amendments were proposed to modify the Constitution. And these were proposed in 1789, right? As soon as Congress met for the first time, they proposed these. So here's a timeline, right? The Constitution was signed in 1787. It was ratified in 1789. It was approved in 89. The first Congress met in 1789. They proposed the 10 amendments in 1789. And these 10 amendments were ratified 2 years later in 91. So again, signed in 87, ratified in 89, Congress met in 89, Bill of Rights ratified in 1791, right? So in the span of a couple of years, we had this great change in government.
How did it go from 13 states to 50?
Well, they were admitted. So Article 4, Section 3 provides a path by which new states may be admitted. Basically, Congress has to consent to the admission of new states. So, the first 13 states were along the eastern shore of the United States, and yet all this land out west. And a lot of it was acquired. For example, President Jefferson purchased from France what's called the Louisiana Purchase, basically the entire middle portion from basically Michigan down to, not Michigan, but just basically from New Orleans up to the middle of the country. And that was a very huge acquisition of land. We bought land from Spain, we got land from England, conquered some from Mexico. Yeah, so just hodgepodge collection throughout the entire country. Some of it was by battle. Right, I'm from Texas, we won a war. Don't mess with Texas. Are you from Mexico?
Yes.
Okay, it's okay. We're all friends here. But they acquired it by a lot of those were the Indians as well. A lot of different means where they acquired territory. Okay, so we bought some from Russia. Alaska was purchased from the Russians. So, yeah, from everywhere. Okay, let's move on.
Where is, for example, Puerto Rico is not indeed a state.
It's not a state.
Like a colony?
It's a commonwealth, or what's called a territory.
Isn't it something associated?
Well, we just one at a time, yeah.
Isn't it an associated state or something like that?
It's not a state. Yeah.
No, it was the association thing, because I recently heard it was something associated, that I didn't get it was state associated or colony associated.
It's a territory. And what that means is it's part of the United States, but not really. For example, they don't get to vote for president. They don't have they have a member of Congress, but that person doesn't actually vote on anything. It's not actually a voting member of Congress. We have lots of territories. We have Guam, a lot of places in the Pacific, which they're not states. They have U.S. passports. They can join the U.S. military. They have post offices there, but they're not states. They're also not citizens by birth. They're citizens by statute. There's a long history of cases I don't have time to go into, but it was deemed that they're sort of lesser because they're not full states. There's a history
Their
that
territories voluntarily if they decide to get out of that.
Puerto Rico could elect for statehood, but there have been a lot of referendums.
Yeah, but in case that they decide like we do another and said no, how they proceed to separate?
Oh, if they want to be independent, you got divorce. Right? You gotta.
You have to make a declaration.
I think if the current government said we want to declare independence, okay, see you later.
That's right.
Good luck with all that stuff. Yeah. I don't, like, adios. Hashtag bye. I don't know. I don't think it'll be something like that. Other questions before I move on? I will finish, I promise. Okay, so we'll start with the first 10 amendments, and the other ones are a little bit less significant. The First Amendment is probably the most famous amendment. And it has 5 main guarantees. First, it says, Congress shall make no law. What does that mean? The First Amendment puts a limit on Congress. They can't enact a law. Doing what? Respecting the establishment of religion. There are lots of ways of reading this. We'll talk a little bit more tomorrow. But the most basic level, Congress can't establish a church. They can't say that, Presbyterianism is the official religion. Can they erect public monuments of religion, a cross perhaps? Can they have a prayer before their session begins? We'll do about that tomorrow. It's complicated. Congress can't prohibit the free exercise of religion. They can't violate rights of conscience. Congress can't abridge the freedom of speech or of the press. What is speech? Does it include burning a draft card or burning an American flag? Is speech a violent video game? Is speech a video of abusing animals, right? What is speech? That's tomorrow. And they can't violate the right of the people to assemble and complain to the government for redress of grievances. Yes?
Are the United States considered as a secular state, therefore, or?
As a what?
Secular?
Is the United States a secular state? That's a good question. I don't think so. There's a lot of religion around. You know where to look for it. It's not a sectarian state for sure, but there's some religion that exists.
With God, the Independence Declaration.
Yeah, every president who's taken the oath of office said, "So help me God," after the oath of office. The very first Congress approved a chaplain to say a prayer before their meetings. There's a lot of religion. You look around. People don't like it so much, but it does exist.
And the motto says, "In God we trust."
It says it's our motto. Our national motto is not equal opportunity, in God we trust, in every piece of currency.
It's in the currency, they trust.
God we trust. The Second Amendment is one which I'm sure is the most foreign to my friends from other countries, one I'm very proud of. It provides a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. And we'll talk about it tomorrow with the Heller case, but what exactly the Second Amendment protects. Oh, I love Europeans for this one. The Third Amendment is kind of obscure. What the hell is this about? If you remember the Declaration of Independence, there was a complaint that the King of England would make troops be quartered, have to live with the citizens. And this says that troops cannot be quartered in times of peace, but in times of war they can if Congress enacts a statute. So this doesn't have much relevance today at all. The Fourth Amendment concerns rights of criminal procedure. That the government cannot conduct unreasonable searches and seizures. What makes a search unreasonable? Tough. Do you have a topic on criminal law coming up? Okay, good. Okay, I don't do that stuff, so you probably learned this already. To have a search, you need a warrant, supported by probable cause. Okay. The Fifth Amendment is a bit of a hodgepodge. Lots of things jumbled there together. That if you want to charge someone with a crime, you have to present a charge to what's called a grand jury, which is basically a group of people who have to say, yes, there's enough evidence to go forward. We have what's called the double jeopardy clause, that you can't be tried twice for the same crime. You ever hear people say, I plead the Fifth, right? What does that mean? You can't be forced to be a witness against yourself. You have to testify against yourself in court. We have the due process clause, very significant, that the government wants to deprive you of your life, liberty, or property. They must give you due process of law. What is due process? Tomorrow. But basically, it's a process that you're due. Certain procedures and rules. They can't arbitrarily deprive you of your freedom. The last one, if the government wants to take your private property, they have to pay you. They can't just arbitrarily take your private property. Okay, any questions so far? I promise I'll get you out here in time. Amendment 6, okay? More criminal procedure. Trials must be speedy. They can't keep you dragged on forever. Trials have to be public. They can't be in secret. Juries have to be impartial. You have to confront your witnesses who accuse you of a crime. And you have the right to an attorney. It doesn't mean attorney paid for by the state, but you have to have an attorney present. They can't try you without one. This is one people always chuckle at. But you have a right to a trial by jury if the amount in controversy is $20 or more. No, it's not adjusted for inflation. That's the full amount. The Eighth Amendment. This is about, now it's about death penalty, right? You can't inflict cruel and unusual punishment. Is a death penalty cruel and unusual punishment? Are there different forms of death penalty? I will not cover the Eighth Amendment, but it's a huge topic.
But that actually, this Amendment 5 says about the...
Yes! So good. I love people who get that one. Yeah. The Constitution says that you can be deprived of your life if you're given due process. The argument that the death penalty is unconstitutional is a tough one to make. They argue that perhaps certain forms of the death penalty are unconstitutional. So maybe like, the guillotine. I don't know. I think French people here, right? They jump your head. Hanging, firing squad. Firing squad is actually pretty quick and easy. It's actually a lot easier than the lethal injections. It's instant. You're done. It's true. But yes, the court grapples over what amounts to cruel and unusual punishment. There are a lot of different tests about whether the protocol and different chemicals you're using are too painful before the person is executed. That answer your question a little bit?
Yeah. I mean, we were just discussing before that there is nothing about death penalty, but actually it is in the amendment, right? So it actually you can be deprived of life if you have been given a just process, right?
Yes. In fact, the federal government actually maybe a week ago, said it would restore the death penalty. It hadn't been used in a while. Very few people actually execute it, but it takes forever for the proceedings. The 9th and 10th Amendments are different. They don't fit in with the rest. They really don't. The 9th Amendment is designed to address a problem, right? Let's say that I write a document and you have these rights. You have a right to free speech, you have a right to religion, you have the right to bear arms, you have the right to be free from searches, and that's it. What will that suggest? That you only have those rights which are written down. That all the rights you have are those given in this document. The 9th Amendment says, no. That's not how to read the Constitution. It says, the enumeration of certain rights, you wrote down certain rights, does not mean that other rights are disparaged. That you retain rights are not written down. And where do these rights come from? No, not from the government. From?
The Constitution.
No, not from the Constitution. They predate the Constitution. From somewhere else.
The natural law.
Natural law. The idea is, think about it like this, right? The First Amendment does not say, we the government give you the right to free speech. It says the right of free speech shall not be abridged. This right existed before the Constitution. You had this right before. The right to bear arms existed before the Constitution. It was not created by the Constitution. What the 9th Amendment is getting at is you have certain rights that are not written down. And we can't write down all rights. There are too many of them. But don't think that your rights are only those in these first 8 amendments. Don't think that. The 9th Amendment was designed to correct, perhaps, an error that someone might think that you only have the rights written down. That's why the 9th Amendment.
Would this also be applicable for not only citizens, but also people acting as government?
What do you mean?
Meaning, for example, if the Constitution gives certain rights to people in Congress, or
Well, just be careful. Let's use our terminology right. The government has power, people have rights. Right?
Yes.
People have rights, the government has power. Government doesn't have rights.
Okay.
Yeah, it's a common, even Americans make this mistake. Government has power, people have rights, and rights limit power, right? The existence of a right means you can't exercise this power.
Yeah, and I agree, and the reason why I was asking this is, for example, of course, I know it's not the same, but when I was learning constitutional law, the understanding that I had is that government it's only allowed to do what the law says,
Right.
or what the law permits.
Correct.
While citizens can do everything that is not prohibited.
Oh, I see what you're saying.
But in this particular
Yeah.
case, since you started saying
Yeah.
that we can do, or the Congress can do those things that are listed, but then we have number 17 that says.
Oh, what a good, yeah, I see your point, right? So during the Constitutional Convention, a debate arose, right? And someone said, could Congress enact a law saying that you can't wear a hat? Right? Of course you can. But someone says, do I have a right to wear a hat? There's nowhere written they have a right to wear a hat. But it was understood that of course I can wear a hat. In the American system, you are presumed free unless the government has the power to enact laws prohibited. There's not a presumption that you are unable to do something like that. The presumption, and this is getting far afield, but my colleague Randy Barnett at Georgetown, who you read his book, he used the phrase presumption of liberty. The idea is, generally you can do what you want unless the government has the power to stop you. And it's a little bit different from the way you framed it. Very different. What country are you from?
Guatemala.
Guatemala. Oh, well, you're in the news now.
Yeah.
I'll ask you at your constitutional court later because I don't know anything about it. Thank you. So the idea is generally you're presumed free unless there's some positive law that allows the government to stop you from doing it, right? Congress can't enact a law saying you can't wear a hat. There's no right to wear a hat, but we're understood to be able to wear a hat if we want to. Good questions. The flip side of the Ninth Amendment is the 10th Amendment, which says whatever powers are not given to the central government are reserved by the states and the people. That is, the people are the ultimate repository, the ultimate source of all sovereignty. That always comes from the people and then the states. Okay, everyone with me? I'll go through the rest a little bit quicker. Okay. You guys are asking questions. I'm going over time, but it's worthwhile because you're asking good questions. The 11th Amendment is, again, kind of strange, and it forms the basis for the first case we'll read tomorrow, which is Chisolm versus Georgia. It effectively says a person can't sue another state. Don't worry about more, we'll get to it tomorrow. The 12th Amendment changed the way presidents are elected. Originally, whoever got the most votes was president, and the run-up was vice president. That was a freaking disaster. It was bad. So now you have the president and the vice president run together. It was a good change. Okay, the 13th Amendment came after the Civil War, and it abolished slavery. It says neither slavery nor involuntary servitude shall exist in the United States. This was the result of a bloody civil war to abolish slavery in the United States. Very significant. We'll talk about it at length tomorrow. The 14th Amendment is probably the most important amendment to the Constitution because it changed the country, right? Before the Civil War, the states could do just about anything they wanted. That led in part to the entire institution of slavery. The 14th Amendment was designed to change that approach. So now the states have their powers limited. It begins, and this is your question. Sorry, first, what's your name again? That's that, thank you. First sentence, right? Who's a citizen? All persons, not men, not women, not white, not black, all persons born in the United States are citizens of the United States. This clause corrected the original Constitution, which did not define who was a citizen. In one sentence, all persons born are citizens. And what do those citizens get? The privileges and immunities, which you asked that before. So now that all people who are born and naturalized in the United States, now someone's going to ask me about non-citizens, right? We're just waiting for the hand to go up. An immigrant isn't necessarily covered by that second sentence because they don't get the privileges and immunities of citizens.
Not the slaves either, because they.
No, they were naturalized. They were born. They were born in the United States.
But the ones that the tribe.
By the time this was ratified, the slave trade was concluded. So they weren't, I shouldn't say concluded, it was going on quietly. But for the most part, these are people already in the United States born here. Okay? And these new citizens would get these rights, these privileges and immunities.
So it was before the 20 years.
This was in 1868. This was it was 100 years later. So the Constitution was in 1789. The slave trade was 1808. This was 1868, so 60 years later.
So the citizen means the people have American passport, or
Yes.
all of the people, they, for example, the people living in Japan and lost the American passport and they.
Well, if you lose your passport, you get another one, right? It's replacement. But you have to be born in the United States, or you're naturalized. Meaning, let's say you marry a U.S. citizen, right? Or you immigrate with a visa and then you become a full citizen, right? So different ways to be naturalized. But yeah, this is people are citizens.
If you're born abroad and your parents are both Americans or.
The answer is actually complicated. The answer here explains Ted Cruz, right? Ted Cruz ran for president in 2016. He was born in Alberta, Canada. But his parents were U.S. citizens, and by law, he was a citizen at birth. Therefore, I think at least, he was a natural citizen. John McCain also ran for president. He was born in a military base in the Panama Canal Zone, which is technically U.S. soil, but it's not the United States. So it gets complicated.
Actually, it's technical because we never was a state.
I'm sorry?
Panama was never a state, so it's a technical thing.
There was a huge debate about whether, almost every president has some issue, and then,
And if you ask a Panamanian, we will have to.
Are you from Panama? Okay. So you don't think McCain was a citizen?
No,
Well,
it was not part of the state. It's a technician is the same thing as you said. Puerto Rico is a technical thing. Sonia and Panama Canal Zone is a technical thing too. It
But
was
there
not
is
a state.
on a treaty.
Really? Oh wow.
It was never a state.
I don't know. But the short answer is, under most people's understanding, a person who is a citizen at birth by statute, by law, is naturalized. I mean, so they are a citizen at birth, so they're covered by this provision.
That's because of the law.
Yes.
They will have those there that.
Yeah, there's some for example, there's some laws that say that, if a child is born to one U.S. parent, the other one's not a U.S. parent, they have to then apply for citizenship, right? But it's automatic, they just have to apply. They are then not a natural-born citizen for purposes of the 14th Amendment. They can't, I'm sorry, they're not a natural-born citizen for purposes of presidency, right? Even if, you have one U.S. parent and the child becomes naturalized, they're a citizen just the same. There's no difference between a natural citizen and a naturalized citizen, with one exception, the presidency. Everything else is the same, right?
The justice for the Supreme Court.
They can be immigrants. We had one I can think of was born in Scotland. There's one justice born in Scotland I can think of. Others, there might be one or two others I'm blank now, but I think Felix Frankfurt I think was born in Austria. We've had foreign justices. Happens. Okay. Next. Nor shall any state deprive any person of life, liberty, or property without due process of law. Wait, didn't we read this already? Yeah. The Fifth Amendment limits federal power. The Fifth Amendment says that Congress cannot deprive a person of life, liberty, or property without due process of law. This is the states. Now, the states are obligated to give people due process before they take away their life and liberty. And the states must give the equal protection of the laws. We'll talk about this tomorrow, but this generally requires people treat equally within the states. Okay. Next.
Sorry.
Yeah, go ahead. No, what's your name?
Divine.
Divine, thank you.
I just have to ask, does U.S. laws allow or the Constitution allow dual citizenship?
Yes. Well, it's a funny question. American law allows dual citizenship. I'm not that sure why, but we do allow it. And the reason why is, anyone here dual citizen in the U.S.? No. When you take the oath of citizenship in the United States, you basically say, I give up all foreign allegiances. But you don't have to. It's like, doesn't actually count. But I give up all foreign allegiances, but I'm still a dual citizen. So it's kind of a weird thing. Not all countries allow dual citizens. Some don't permit it. But some do. You're allowed to. Okay. Oh, yes.
I know it's a weird question.
There are no weird questions here.
In the absence of the vice president, who can run the president? You don't have the
Yes. So we've actually the vice president is basically useless. It doesn't actually do anything except for break time in the Senate. It's a worthless office.
If the president dies.
Right. If the president dies under the current statute, the Speaker of the House of Representatives becomes president. We have an order of succession where I think it's the Speaker of the House and then the President pro tempore of the Senate. There's a chain of authority of who gets to be president.
Okay, is the justice of the Supreme Court in this line?
They are not. No. Thank God.
I asked you because in Brazil, the justice from the Supreme Court.
Really?
Yes.
have to be-
Oh wow, that's fascinating. Has that ever happened?
No.
I mean, generally the way it works is
Yes.
if the president dies, the vice president becomes the president, right? But if there's no vice president, then it's the Speaker of the House.
Okay.
What happens if the vice president dies? The president picks a new vice president. With the Congress has to confirm. So, for example, when President Nixon was in office, his vice president resigned. Then Nixon picked a new vice president. His name was Gerald Ford. Then Nixon resigned, and Ford became president. So Jerry Ford was president when he was never elected president or vice president, and he lost re-election. So he was only president, never be elected anywhere.
When can the vice president be in charge of things?
If the president's dead,
What
or if he's sick.
with dictation?
Yes, I was going to mention that. If the president is under anesthesia, so for example, President George W. Bush had a colonoscopy, and he went under anesthesia for however many hours, he basically handed over to Cheney for a few hours. Perfect. When President Reagan was shot, for some period he was unconscious, and George H.W. Bush was president. In fact, we are now at George Washington. The hospital Reagan was taken to is about 2 blocks that way. It's called the Ronald Reagan Emergency Room. And there's a joke where Ronald Reagan told a surgeon, "Hope you're a Republican." I don't know if he was, but he survives. Oh yeah, go ahead.
Is there a real designated survivor?
Yeah, that's a TV show, right? So generally during the State of the Union, where the entire government's in one place, one member of the cabinet stays home for safety. So that is a real thing.
Oh, really?
Yeah. So they usually pick, Secretary of Agriculture, right? Someone's not very important. I shouldn't say that. But not a very significant cabinet official who stays home in case, a nuclear bomb detonates in the Capitol and the entire government's wiped out. We're all screwed, right? If that happens, we're done. But there's some continuity of government in place.
Where is that written? Is it?
I think it's a custom. I don't think it's written anywhere, but it's well, we do have a succession act that in the event that the president dies, then the vice president, then the Speaker of the House, then the president pro tem of the Senate. It goes pretty far down. I think the Secretary of State is on there also, a couple rungs down. There's a lot of moving parts. We're almost done. I will get through the entire thing, I promise. All right. Skip section 2. Thank you. Okay. The 15th Amendment. Yes?
When do we speak of the Bill of Rights? I don't really
The Bill of Rights is the first 10 amendments.
It's the first.
Amendments 1 through 10.
Why is it called Bill of Rights?
Good question. The phrase Bill of Rights didn't really come around until much later to refer to the 10 amendments. Originally, it was just called the first 10 amendments, and then later this thing kind of took hold that these are important rights to have. But that phrase wasn't used at the time the document was drafted. It came around predominantly in the late 19th, early 20th century. Yeah, that phrase.
Yeah.
It's easy, 10 amendments, 10 commandments, there's a nice symmetry.
And the other 17 amendments later, after the 10, how do they have a specific name?
No, they're numbered. First Amendment, 11th Amendment, 12th Amendment, 13th Amendment, 14th Amendment. Not very attractive, right? The 15th Amendment says that the government cannot deprive the right to vote based on your race, color, or condition of servitude, just to ensure that the freedmen, the freed slaves, were able to vote, but not the women. That would come later. The right to suffrage would be in the 19th Amendment. We'll get there in about 2 minutes. The 16th Amendment was the Income Tax Amendment, right? Under the original Constitution, taxes were based on how many people were in a given state. Here they can now tax directly in income, which is why whenever I get a paycheck, there's a certain chunk that's taken out of it. The 17th Amendment changed the way senators were elected. Originally, senators were elected based on the state legislatures, but now people could vote for their senators. This was a significant change in how our government functions. 18th Amendment was one of the unpopular things, prohibition. It banned the sale of alcohol. This was a very popular movement in the early 20th century of temperance, right? To ban alcohol. I'm going to skip ahead. The 21st Amendment repealed the 18th Amendment. So we had an experiment with prohibition, and it was repealed like 30 years later. In fact, there's a bar not too far from here called the 21st Amendment in honor of the repeal of prohibition. It's in Georgetown. It's a couple blocks that way, so it's actually pretty close. What was that? Let's go back. 19th Amendment, suffrage for women. That the right to vote cannot be denied on account of sex. That came almost 40 years after the right of suffrage for African Americans, so it took some time later. The 20th Amendment, not very sexy. When does the president take an oath of office? January 3rd, right? It shrunk the lame duck period. The president used to take his oath, I think, in March or April. Now it's closer to the election. We did the 21st Amendment, repeal prohibition. 22nd Amendment's term limits. From George Washington until Franklin Roosevelt, every president served at most 2 terms. Some 1, some 2. Franklin Roosevelt was elected to 4 terms. This changed it. Now you're limited to 2 terms in office. The 23rd Amendment concerns the place we're in right now. That D.C., District of Columbia, can have electors for the presidency. Right? D.C. does not have a voting member of Congress, but they can vote for the president. The 24th Amendment prohibits what's called poll taxes, right? Which is basically a fee to vote, because a number of states were charging people to vote as a means to disenfranchise them. That's not allowed. The 25th Amendment is what happens if the president dies or becomes sick. They're fairly complicated rules. If you want to read through them on your own, I encourage you. It's actually very dramatic. It's like a spy thriller. If this happens and that happens. But the short answer is the president's not going anywhere, right? He's not going anywhere until his term's up, unless he dies. But he's not going anywhere. Almost done. 2 more. The 26th Amendment. We started 15 minutes late, so I'm actually right on time. The 26th Amendment gave the right to vote to people who were 18. It used to be 21. They dropped the age down to 18. And the last one, 27th Amendment, says that Congress can't raise their own salary. That any increase in salary goes into effect in the next Congress. So if Congress votes to raise their own paycheck, they can be thrown out of office because they're a bunch of selfish bums, right? So you can't raise your own pay. Now the fun part, this amendment was first introduced in 1789. It did not get enough votes until 1991, or maybe 92, off by a year. So it took 200 years to get the votes to approve this, and it's now the 27th Amendment. And we are done. Thank you so much, and I'll see you all tomorrow morning. Thank you. Thank you. One second. Just one second. Hold on.